In our debates about the notwithstanding clause, we often imagine that Section 33 is to the rest of the Charter what an apex predator is to the food chain, right? The apex predator gobbles up other less fortunate creatures, and Section 33 gobbles up other constitutional provisions. And what I want to suggest today is, as a matter of constitutional interpretation, that is not sustainable. Section 33 is not the strongest norm in the Charter. The strongest norm in the Charter is the guarantee of gender equality in Section 28. And unlike other Charter rights, this right is not susceptible to justified limitations under Section 1, nor is it susceptible to denials under the Section 33 override. In short, the Charter has more than one notwithstanding clause, and we need to understand the relationship between them to understand the relationship between equality and legislative power. So in 2019, Quebec enacted Bill 21, and the act prohibits certain government employees from wearing religious symbols in the exercise of their function. At Superior Court, Justice Blanchard observed that the evidence undoubtedly reveals that the effects of Bill 21 will have a negative impact on Muslim women first and foremost. Quebec's National Assembly enacted Bill 21, indicating that the bill operated notwithstanding all of the Charter rights that are susceptible to the override, Sections 2 and 7 to 15 of the Charter. And Hawk brought a constitutional complaint complaining, among other things, that the act violated Section 28 of the Charter, a neglected, under-theorized provision on which there's very little case law. And the provision states the following: notwithstanding anything in this Charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. And the whole question here is how to interpret this provision, and the literature presents two different interpretations. So interpretation 1, this provision tells you how to interpret other provisions, namely sections 2 to 23 of the Charter. It's an interpretive guide to determining the scope of other constitutional provisions. And the opposing interpretation, this provision denies the power of legislative bodies to perpetrate gender inequality. And in Hawk, the Quebec Court of Appeal spends about 90 paragraphs arguing for the superiority of interpretation 1. So we have a rare, full-bodied discussion of how to interpret Section 28. And the Quebec Court of Appeal says, okay, take the provision, and the provision has two parts. So there's an introductory statement, notwithstanding anything in this Charter, and then there's the main proposition. The rights and freedoms referred to in it are guaranteed equally to male and female persons. And the point of the main proposition is to establish, the Court of Appeals says, a rule of interpretation, namely to take gender equality into account when interpreting the scope of other constitutional rights. In turn, the point of the introductory statement, notwithstanding anything in this Charter, is to assert the supremacy of the main proposition over other interpretive rules found in the Charter. So, for example, if there's a conflict between gender equality on the one hand and the preservation of our multicultural heritage under Section 27, gender equality prevails. Now, once you see things this way, if you have the Canadian Charter of Rights and Freedoms and Quebec enacts Bill 21, overriding Sections 2 and 7 to 15, once you conceive of Section 28 as an interpretive rule for the interpretation of other rights in the Constitution, when these rights have been overridden, there's no substance, or as the Superior Court puts it, substratum to which Section 28 applies. Section 28, it's an interpretive rule for other rights. If those rights have been overridden, Section 28 lacks its condition of application. Now you might ask, well, why should I see it this way? Why should I adopt interpretation 1? And the Quebec Court of Appeal says there are two reasons. The first is location, location, location. We have the Charter. Section 28 appears under the heading general, okay? And the Court of Appeal says all the provisions immediately surrounding Section 28 and grouped under the same heading set out in one way or another interpretive provisions. So you're in the interpretive section of the Charter. Section 28 then has to be interpreted as merely giving effect to other provisions. And they have another reason why you should see it this way, and this has to do with duplication. They say any other interpretation of Section 28 would duplicate Section 15 of the Charter, which already enshrines the equality of individuals without distinction based on various grounds, including sex. So the claim here is, if you abandon interpretation 1, you're going to collapse the distinction between Section 15 and Section 28 of the Charter, and you're going to render a constitutional provision redundant. Okay. With this, the Quebec Court of Appeal issues its conclusion: the text of Section 28 hardly lends itself to any other interpretation. Now, when I read this case last February, I wrote in the margins, but you yada yada'd over the best part, that as a textual interpretation, this was surprisingly non-textual. And so I want to suggest that there's certain problems in the Quebec Court of Appeal's interpretation, and that interpretation 2 doesn't present any of these problems, and it establishes that gender equality is the strongest norm in the Charter. So start with the Quebec Court of Appeal's understanding, right, interpretation 1 of this provision. Right, as we've said, it divides into an introductory statement and a main proposition, and there's a significant problem with respect to the introductory statement. The introductory statement reads, "Notwithstanding anything in this Charter." If the point of the main proposition is to establish the supremacy of taking gender equality into account as a matter of interpretation in determining the scope of other Charter rights, and the whole point then of the introductory statement is just to establish the supremacy of Section 28 over other interpretive principles in the same section, one would expect the text to read as follows: "Notwithstanding anything in sections 25 to 31 of the Charter," or "notwithstanding anything in this section." But the text doesn't say that. The text says, "Notwithstanding anything in this Charter." And now the big reveal for everyone following at home: Section 1 is in this Charter. Section 33 is also in this Charter. And so the provision seems to be saying, notwithstanding the notwithstanding clause, the rights and freedoms referred to in it are guaranteed equally to male and female persons. Now, in terms of the location argument, the Quebec Court of Appeal has a problem here too, which is that the section in which Section 28 appears does not say interpretive principles. It says general. It says general because everything in this section applies to other provisions in the Charter. But when the Charter wants to formulate an interpretive principle, as Professor Carey Frock notes, it has a way of doing so. It begins, "This Charter shall be interpreted," and other provisions in the same section begin, "This Charter shall be construed." When the Charter wants to use interpretive language to establish an interpretive provision, it knows how to do it. Okay, now, Section 28 doesn't use this interpretive language. Further, it uses the term guaranteed, and guaranteed is a term associated with rights elsewhere in the Charter, see sections 1 and 24. Okay, now we still have to deal with the duplication argument. Does interpretation 2 duplicate sections 15 and 28? And I want to suggest to you that it doesn't. Now, those of you who are suffering through my constitutional law class will have seen this before. Constitutional rights have 2 structural features. They have a scope, or a reach, or an ambit, which consists in the protections that the right secures to its bearers, and they have a strength, which consists in the power of the right to withstand opposing considerations. And these 2 structural features are the way we distinguish between different constitutional rights. Now, Section 15 and 28 on interpretation 2 have a distinctive scope and a distinctive strength. With respect to scope, Section 28 protects the equality of every individual on a variety of different grounds. And as a matter of strength, Section 15 is susceptible to justified limitations under Section 1 and to the override under Section 33. Section 28 is different. Its scope is narrower. It protects only gender equality, and its strength exceeds that of Section 15, whereas Section 15 is susceptible to justified limitations and to the override. Neither of those things is true about Section 28. Notwithstanding anything in this Charter, as I've said, means notwithstanding Sections 1 and sections 33. Gender equality is the strongest norm in the Charter. Now, from this, it follows that these provisions do not duplicate each other under Interpretation 2. The Quebec Court of Appeals argument is not persuasive. If each provision has a distinctive scope and strength under Interpretation 2, one can't say that they collapse into each other or that one renders the other redundant. They each have distinctive work to do under Interpretation 2. And further, it means that Section 33 is not the apex predator. It's not the strongest norm in the Charter. There's a right that cannot be limited and cannot be overridden, and that right is Section 28. It's the strongest constitutional norm. Now, when the Quebec Court of Appeal says the text of Section 28 hardly lends itself to any other interpretation, they have a point. So long as one's not talking about the Charter, so long as one's talking about the versions, the formulations of provisions that were not actually accepted in our constitutional negotiations. So there was an earlier version of Section 28, which said, notwithstanding anything in this Charter except Section 33, in which case the Quebec Court of Appeals interpretation would be exactly accurate. But this provision, this formulation, this language of except Section 33 was rejected in the drafting of the Charter because it did not take gender equality seriously. And further, conversely, there was a provision, a formulation of the override in 1981 that explicitly indicated that the override trumped concerns of gender equality. But that, of course, is not the version of the override that was adopted. Why? It didn't take gender equality seriously. And so we've reached this curious state of affairs where the Quebec Court of Appeal has interpreted the Charter we have in a way that makes nonsense out of the text, but that makes perfect sense out of the text that Canadians rejected. Okay. Now, if this is right, notwithstanding anything in this Charter, the rights and freedoms referred to in it are guaranteed equally to male and female persons. This establishes a very simple principle. The legislator is under an incapacity that prevents it from perpetuating gender equality as a constitutional matter. And that means it doesn't matter if Bill 21 uses the override and tries to immunize the legislation from challenge under Section 2A and Section 15. If the law has adverse impacts on gender equality, which I think is undeniable, then it is unconstitutional and cannot be justified under Section 1 and cannot be overridden under Section 33. And this brings me back to the statement with which Gregoire directed our attention to right at the beginning of his remarks today. If Interpretation 2 is the only viable interpretation of Section 28, we need to revisit the seminal statement in Ford. Section 33, the Supreme Court wrote, lays down requirements of form only, and there's no warrant for importing into it grounds for substantive review of the legislative policy and exercising the override authority in a particular case. If Interpretation 2 of Section 28 is persuasive, then Section 28 is the warrant for substantive review of the use of the override on grounds of gender equality. My point here is very simple. Gender equality is not part of the diet of Section 33. Thank you.